Tonight, we begin with a decision that legal scholars, civil liberties advocates, and law enforcement officials had feared, anticipated, and debated for years. A ruling that unfolded not over decades of slow legislative change, but in a single unanimous vote. A single vote that reshapes the relationship between Americans and their government. A single vote that draws a constitutional line no badge can cross. A single vote that puts every police department in the country on notice. What the government had long assumed it could do, walk through your door under the right circumstances without a judge's approval, crossed a line that the Constitution had always drawn. And when that moment arrived before the nation's highest court, the justices did not hesitate. They responded with clarity, unanimity, and force. 9-0, not 5-4, not 6-3, 9-0. For years now, there had been signals, not from official press releases, not from formal policy announcements, just quiet rumblings that the Supreme Court was preparing to address something that had grown deeply uncomfortable in American legal life. The Fourth Amendment has always been there. It has always said the same thing. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. But courts have been creative. Law enforcement has been persistent, and over time, exception after exception had been carved into that amendment like grooves worn into stone. Exceptions for emergency, exceptions for hot pursuit, exceptions for exigent circumstances, exceptions built on exceptions. Legal scholars who monitor Fourth Amendment jurisprudence know the warning signs, the slow erosion of reasonableness standards, the broadening definition of what qualifies as an emergency. The deference given to officer testimony in warrantless entry cases, the sudden silence from appellate courts on pushing back, all of that had been accumulating. And whenever constitutional guardrails weaken quietly, it usually means something loud is about to happen. Today, it did. Early in the court's term, legal watchers detected what they described as a realignment in how the justices were approaching police power cases, including precedents that had not been seriously challenged in over 3 decades. These are the kinds of cases that the Supreme Court only agrees to hear when they are signaling something very specific. A correction is coming, a standard is shifting, or a line is being redrawn. Observers didn't know which category this fell into, or whether it fell into all 3 at once, but what they did know was that the court was changing its posture on warrantless home entry. And when the Supreme Court shifts its posture on Fourth Amendment protections without explanation, even by a fraction, every constitutional law expert in the country pays attention. Today, we got the explanation, and it was not subtle. The court ruled unanimously that police cannot enter a person's home without a warrant, and that prior lower court decisions granting officers broader discretionary authority to enter during ambiguous situations had been wrongly decided. The ruling issued by the Supreme Court today was not routine. It was not a narrow technical clarification. It was not symbolic language buried in a footnote. It was a direct and sweeping constitutional declaration. Legal analyst after legal analyst described the court's opinion as historic, unambiguous, and perhaps most importantly, enforceable in a way that lower courts cannot sidestep, but sweeping rulings only hold if enforcement follows. If police departments acknowledge it, if courts apply it consistently. The civil liberties community did not wait to celebrate cautiously. In fact, the response from constitutional advocates today was among the most unified we have seen in a generation. Here is what we know. Within hours of the decision, the American Civil Liberties Union issued nationwide guidance. Legal aid organizations began updating their public materials. Defense attorneys across the country flagged every pending case involving warrantless home entry for review. These weren't routine press releases. These were emergency legal briefings, the kind of rapid mobilization that only happens when something fundamental has shifted. Tonight, constitutional scholars confirmed that the court's ruling targets the very framework that had allowed police to enter homes under broadly interpreted emergency or exigent circumstances doctrines, including situations that had recently been used to justify no-knock entries in cases where analysts believe no genuine emergency existed. The court moved before that doctrine could expand further. They addressed the standard for what constitutes a real emergency. They addressed the burden of proof on law enforcement. They addressed the consequences for evidence gathered during unlawful entry, consequences that cut directly to the heart of prosecutorial power. In other words, the court targeted the legal infrastructure that made warrantless home entry survivable in court, the doctrinal foundation that would have kept these cases alive. This is what made today's ruling so significant. The government's approach to warrantless home entry wasn't just policy. It was operationally embedded in how cases were built, prosecuted, and won. It represented the kind of institutional practice that could continue indefinitely if left unchecked. And the court, understanding that fully, responded with precision, not reactively, not impulsively, but constitutionally. They didn't limit themselves to the narrow facts of one case. They didn't leave a loophole for creative reinterpretation. They hit the standard itself, they hit the doctrine itself. And here is where the story becomes even more consequential. Legal historians now believe that today's ruling was, in part, a direct response to what the court perceived as a slow collapse of Fourth Amendment norms in the years following a series of permissive lower court decisions. The government had been testing whether the court would push back, whether the justices would allow the erosion to continue quietly. Instead, the opposite happened. The court didn't issue a narrow opinion that future judges could carve around. They issued a ruling so direct, so structurally clear, that even the most aggressive prosecutorial interpretation will struggle to escape it. You don't get a unanimous Supreme Court decision easily. But today, the Constitution got one. Legal commentators speaking to press describe the decision as a doctrinal reset, a way to restore the Fourth Amendment's original protective boundary around the home. And the court proved today that the home remains the most protected space in American constitutional law. Their opinion was not only clear, it was written with a precision so deliberate that future courts have very little room to dilute it. That precision matters because it shows the justices understood the stakes. It shows that the court is not a passive observer of constitutional drift. It is an active guardian. As legal analysis continued rolling in throughout the day, we learned more about the scope of this ruling's reach. Criminal defense attorneys across all 50 states immediately began filing motions to suppress evidence gathered through warrantless home entries in ongoing cases. Police departments in major cities issued internal memos directing officers to suspend certain entry protocols pending legal review. Federal agencies operating under guidelines that had relied on the now challenged doctrines reportedly began an internal audit of their field procedures. This wasn't just a ruling about one family's front door. This wasn't just a win for one defendant in one case. This was a structural recalibration of police authority in America. This was a restoration of what the founders considered the most sacred boundary, the threshold of the home. And that boundary is the one thing law enforcement power has struggled to respect consistently since the expansion of the war on drugs in the 1980s. For every procedural advance that eroded Fourth Amendment protections, the court has now countered with something that fundamentally reasserts them. Remember, the government thought warrantless entry exceptions could be expanded indefinitely. They thought the courts would continue deferring to officer judgment without scrutiny. They thought the doctrine of exigent circumstances could stretch to cover nearly any situation where an officer claimed urgency. But tonight, the exact opposite is confirmed. The exception has been narrowed. The officer's word alone is no longer sufficient, and the home, your home, is once again the constitutionally protected fortress it was always meant to be. What makes this moment so powerful and so politically significant is that the ruling arrived at a time when public trust in law enforcement is under extraordinary pressure. Reform advocates want accountability. Civil liberties organizations want structural change. Police unions want clarity on what their officers can and cannot do. Prosecutors want to know which cases are now vulnerable. And the public, the ordinary Americans living in those homes, want to know that the Constitution still means something when the knock comes at the door. Today, the Supreme Court answered that question, unanimously. The court's opinion, now published and available in full, was designed to signal that the judiciary is not willing to allow the Fourth Amendment to become a suggestion rather than a guarantee. The justices said plainly that warrantless home entry under ambiguous circumstances is inconsistent with constitutional protections. That is restrained judicial language for "this ends now." You don't hear that tone from a unanimous Supreme Court unless something profound is at stake, and something profound was. Meanwhile, constitutional attorneys addressing the public today spoke in clear, direct terms. They said, if police come to your door without a warrant, you have the right to refuse entry. They said, you are not required to let officers inside your home simply because they ask. And they said, any evidence gathered in violation of this ruling may be suppressed. It may not be used against you in court. These are not abstract legal theories. These are your rights confirmed today by every single justice on the nation's highest court. Here is what makes the situation even more significant. Today's ruling did not exist in isolation. Alongside the primary Fourth Amendment holding, the court also signaled skepticism toward related doctrines: the independent source rule as applied to home entries, the attenuation doctrine in certain residential search contexts, and the good faith exception when officers had no warrant and no genuine emergency. All of this moved in the same direction. When the Supreme Court moves multiple doctrines at once, it means a fundamental philosophical shift is underway, not just a case-by-case correction. Legal analysts are now considering several possibilities for what comes next. One is that Congress will move to codify these protections into statute, making them harder for future courts to quietly erode. Another is that police training across the country will be fundamentally restructured to reflect the new standard. A third possibility, the one most important to watch, is that thousands of convictions built on evidence from warrantless home entries may now face serious legal challenge. Today, the court gave defendants a tool, and defense attorneys will use it. What we're watching now is a test of institutional follow-through. The government must demonstrate it will comply, not just in written policy, but in practice. Law enforcement must show that constitutional rulings are not obstacles to work around, but standards to operate within. And the public must understand that this ruling only protects you if you know it exists. Tonight, we've heard from legal organizations who are now distributing Know Your Rights materials directly to communities most affected by aggressive warrantless entry practices. They say the ruling is a generational shift. They say it restores the constitutional balance that decades of exception building had upset. And they say the government's long-standing assumption that it could enter homes on broad discretionary grounds is now constitutionally dead. Their response today, swift, organized, and grounded in the ruling itself, sent a message to law enforcement that the era of easy warrantless entry is over. And it sent a message to every American that the Constitution still stands between your front door and unchecked government power. As the legal landscape continues to evolve in the days ahead, we expect more details to emerge about how courts, police departments, and prosecutors will adapt. But what we do know is that today's ruling was timely. It stopped an erosion that had been accelerating for decades. It restored a protection that millions of Americans didn't even know they had lost. And it reminded every level of government that the Supreme Court, when united, remains the final word. And tonight, for the first time in a long time, the Fourth Amendment appears to have teeth again. The exceptions are quiet, the carve-outs are narrowing, and when constitutional protections speak with a unanimous voice, it means the court has chosen its position carefully. Because today, every American learned something important. Your home is protected. A warrant is required. And the Supreme Court, all 9 justices, agree. This story is far from over. But tonight, one thing is absolutely clear. The Constitution still means something. Your rights are real, but only if you know them. And now you do. We will be here, watching every legal development as the next phase of this landmark ruling unfolds.